you'll notice, those are big changes. Then we'll go through the biggest reminders and then just some things about contracts in general. But everyone always asks, actually, I might have lost my control, but that's okay. Can you the next one?
Let me go back to it and I'll hit it again. You should be good now.
Oh, perfect. Thank you. So everyone always wants to know who I am, because I'm actually not with Forward Title. I'm with Agents National Underwriting. So the relationship kind of with realtors, title, underwriter is y'all, of course, bring your file to Forward Title, to your title company, you open your order, right? They work your whole file, they run exam, they give you a commitment, they get you to the closing table. So I'm the underwriter whose name is on the policy of title insurance that your buyer gets or that the lender gets. So I'm with Agents National. They also use DOMA. I've worked with First American before. I've worked for Fidelity before. We're all underwriters, so we're insuring that policy. So I talk to Kat at Forward Title all the time. So when they have legal questions about something that's wrong with the property, they come to me. So I'm an attorney and an underwriting counsel for Agents National. But that's the relationship. I call it the triangle, because I never work with realtors directly, but y'all, of course, are working with the title team that I work with. So I am not from Texas. I'm from Kentucky. Grew up there, went to school there, went to law school there. Then I moved to Florida and worked for Fidelity. I was a claims attorney right out of law school for a couple of years. That's how I learned title and real estate, which is a good way. It's not a fun way because you're dealing with everybody who has title claims, but it's a good way because you learn all the bad things that can happen. Then I moved to Texas and switched to underwriting. Now I'm trying to prevent all the bad things from happening on the front end. But I've been with Antic about a year. Was at First American right before that for 2.5 years. So I love underwriting. I love working with our agents, and I like teaching, which is why I'm here. So those are my shepherds. I have 2 large and in charge German shepherds. But who are y'all? I'd love to hear names, how long you've been doing it. If there's anything you want to learn today specifically, throw that in.
I'm Mina.
Okay.
And I'm a newbie.
Okay.
I got licensed in February, so I still don't know anything.
Awesome. Okay. You know things, but you're new. Okay. Okay.
I'm Savannah. I've been doing this for only 2 years, so I still have lots to learn as well.
For sure.
My name's Greg. I know this about 2 years. So
Okay.
I'm eager to learn anything.
I'm Kevin. I've had my license about 6 years.
Okay.
Did this right out of high school. So here I am.
Awesome.
I'm Brian. I'm a broker and have been a realtor for almost 19 years.
Awesome.
And I'm the brokerage manager here and kind of do these meeting things and get interesting people to come teach us things.
Okay.
Because I'm looking forward to this class too.
Yeah.
I learned something on the contract yesterday that I didn't know.
Okay. Good deal. Always.
Always.
You will
Always
always be
learning.
learning new
Always.
things. I learn something every day.
My name is Danielle. I've been in real estate for, I guess, a little over 6 years. Yeah, so I work this market and then Central Texas as well.
Oh, cool. Okay.
I'm Gracie. I've been a real estate agent 7 months.
Okay.
Yeah, so I'm pretty now.
Okay. Awesome. Good deal.
Sheree?
Hi, I'm Cherie Phillips. I've been licensed since 16, and I'm the market leader in Bell County.
Awesome. Nice
And-
to meet you.
And Angela, are you there?
Hi, I'm Angela. I've been in real estate for about 5 years and I just started full-time real estate in September.
Okay, cool. Very good. Well, I love when we have a diverse crowd because I think hopefully even you will learn something and you will learn something hopefully today. So that's the goal. But like I said, I want it to be conversational. I'll watch my time and we'll finish a little before 1. I'll leave some time for questions. And if y'all have them as we go, please just chime in. But biggest things to remember, the nice thing with TREC is all of their forms are very easily findable. It's all on their website and they give really good summaries about the changes that are happening or that are forthcoming. So you can always go there. So that's my biggest advice. You know, if you ever want to read up on a contract or if you're learning and want to look at addendums and different things, go to the website, pull, read, kind of research and dig around. There's a very good summary of the 23 changes on there. So if you ever want to access it after, and of course, Brian has the PowerPoint too, but I'm going to go through them, but you can always find them there. Gives very good bullet points and they're very non-substantive. which is good. So they're not anything huge this year. But TREC, of course, promulgates all the contracts for realtors' use in the state of Texas. And I say we have 6 main ones, but the biggest one that's most commonly used is the 1-4, right? Does most everyone do all residential or mostly residential? Yeah. Okay, cool. So we've got the 2 for resale, the 1-4 that we're going to talk about today, and then the condominium contract. If you ever do construction, there's 2 construction contracts that TREC promulgates. One is a new home complete and one is incomplete. I think TREC does some things well and some not great with their naming and terms. That's a good one that they've done because it's pretty straightforward, right? If the construction is complete, if it's done, you use that contract. If it's incomplete, you use that one. So that's an easy thing. And then we have 2 for land. So there's a farm and ranch specific contract if you're ever dealing with that. And then there's a basic unimproved land as well, which would be acreage, that's not being used for any kind of farm and ranch use. So the 1-4, most people know, but sometimes it can be confusing, right? Because condominiums are for family use as well. But the 1-4, single dwellings, duplex, triplex, fourplex, and townhomes. That's what all fits within the 1-4. And then you have the condominium contract or the condo contract. And that's, of course, when it's within a condominium association. So you've got common elements there, meaning maybe there's a pool, maybe there's a dog park, walkway paths, things that they get access to and use typically. And then there'll be, of course, condominium restrictions and all of that comes with that property, making it different from maybe, of course, a single family home. That's different from townhouses. Get a little funky, right? Because they might be in a community like that, but it's not going to be a condominium association. It's probably an HOA there or a POA that runs the townhome community. Other TREC contracts, these are the ones I just listed. And I already mainly went through these, but again, the incomplete, closing's going to occur sometime after completion, but you're doing the contract while it's being built, right? So this is when folks come in, either at the very beginning and want to build ground up, or they come in, mid-process where it's not done. I'd say that's the most common one, right? If people want to do construction, that's the contract that's going to be used. But then the example I always give is maybe it's one of the last couple homes in the neighborhood, or it's a spec or it's sat there for a while. It's totally done and no one's bought it. So that's when you would use the complete contract. It's still a new home, but no one's lived there yet. And it's complete construction. Unimproved, there's no buildings or additions on it, so there's not a house. So meaning it's unimproved. That's a title term you'll hear a lot, improved or not. And then farm and ranch, you're selling rural property, and then it's going to relate to farm and ranch in some way. Maybe they grow crops, maybe there's cows, maybe it could be a variety of things, but it's going to meet that usage, which is why it meets that contract.
For the unimproved contracts, yeah, you can you use that and you buy that land, but you can put like a house and stuff on that land, right?
Yeah.
If it doesn't have anything
Currently.
on it and it's not going to be used for farming.
Exactly. So when you're doing the actual contract, it's currently vacant.
Yeah.
It could be used, for whatever in the future.
Okay.
Yes, exactly right.
With farm range, what's
Yes.
the rule of thumb when you use the farm range versus the 1-4? Is there like a good, anything over 10 acres, anything 5, anything with barns, anything with ponds? Like, what's the metric to use over using the farm range over that 1-4?
That's a great question. I would say anytime where there's some kind of predominant use with farm and ranch. So, let's say my example I use is 1-4 you would use if it's a lot and block, but maybe they have chickens in the backyard or, something small like that. And then when you get bigger, I would say if there's a substantial, which I'm using lawyer words, which is horrible, but if there's a substantial use of farm and ranch, right? So maybe if it's a small, let's say it's 10 acres and there's a house and they just have a couple gardens, 1-4.
Mhm.
If they've got pastures of cows, maybe full, pastures of, they've got corn, they've got different major crops, farm and ranch. Does that help some?
Yeah, I've always been told that there is farm equipment involved. So like barns,
That's a good rule of thumb.
chutes, fencing,
Tractors.
any of
I've sold so many tractors.
Well, but it's, so it's like so there was a lot that I was doing down in Bell County, but it had a cattle, like to
Chute.
pass through the
Yeah.
chute. It wasn't currently being used for farm and ranch, but that's what it historically had been, and there were some equipment type things on it.
Yes. I think
That's
that's a
always
good
the
rule
rule
of
of
thumb.
thumb.
Yeah,
If it's unimproved land, I mean,
yes.
raw land. It's about what it's
Yes,
not.
no, for sure, for sure. I think that's a good one, but it's all about how much it's being used for that, for sure. So February 1st, what changes we had? Mostly minimal. When I say minimal, I mean they swapped words for other words. The way I describe every year what TREC does is they try to make the contract more consumer friendly and understandable, right? Because some of us are new. We're still learning the TREC contract. Imagine your first time homeowner who is signing this. They have no clue what any of it means, right? And so that's where y'all can come in and be really good assets and valuable to them, is explaining different things about it. But every year TREC, I think, tries to make it a little more clean, a little more understandable to the common person. And so that's what they've done. They capitalized escrow agent throughout the whole contract, which I think is so that it stands out for escrow agents, so they can kind of find where their duties are a little easier. There's not a great rhyme or reason why they did that, but I think also previously, some of them were capitalized and some were not. So they've made it unanimous. There's some new other words, new check boxes. They've added some definitions, which those are the things that are most helpful, right? When, your common lay person is reading the contract. If we define more words, then they'll understand it a little bit better. But it's nice that TREC, even online, and I'll get to a slide that shows it, they call them non-substantive. So it's nothing, that you really need to learn or spend a lot of time on. But I say there are 3 big changes or major changes. And they're really not, but of everything that got done, they are the 3 biggest. So we'll get to the exact page where it is, but section 6, they've added a new section where you list if the property is in a PID or in a MUD. So that's public improvement district, municipal utility district. There aren't a lot in the Fort Worth area. Houston, we see a lot of them, and some other counties we do, but it's always been a duty for realtors and for the parties to disclose if your property is in one of these locations, but it was never a spot in the contract. So now they've added a line within the contract where you list if it is in a PID or it is in a MUD. We went to Austin for the weekend. There's a lot of PIDs and MUDs around Austin. So we rented a house by Lake Travis, and there's signs, this is in the PID district number, whatever. So anyway, it's always been the duty to disclose it, but now there's actually a section for it where you list.
And one thing to note, that a lot of the new construction areas that we have going are all in PIDs.
Yes.
They're putting everything that's going like north and west, they're in a PID. They're in a public improvement district. And they've actually retrofitted some of the areas where I used to work in Keller and Heritage.
Okay.
We did never have PIDs. And then I put a house on the market. I told y'all this story, put a house on the market. We get 2 weeks before closing and I go, wait, there's a PID.
Yeah.
And Brian messed up because I didn't check. But they retrofitted a PID into Heritage.
Right. And they do that sometimes now for sure.
And
So-
for the PID and the MUD, we can find that on the tax record, right?
Yeah,
Is there
remember,
anywhere else, or is that just the place?
that's a really good place to start.
Probably the easiest place to start.
Go to the tax record and it'll tell you what the taxes are. And it's included in the tax number that you're putting on MLS.
Mhm.
It's just, if you see that, you know that you have to give them that form
Okay.
that says, hey, you're in a PID, you're in a PID.
And you would list that in the transaction desk where you put the listing.
Absolutely.
Live, okay.
And then title's gonna see it too.
I was gonna see it, and they're gonna
So
run.
if it gets missed, it's like,
Yeah, it will get found once you open the order, for sure. The second change, we've got section 18. This is where it talks about escrow agents' duties with earnest money, handling all of that. So always with earnest money, right? If an order cancels, the theory and what you're supposed to have always done is get a release signed by both parties, allowing the earnest money to be released to whichever party was not at fault, right? It didn't used to say you need to do that before releasing the earnest money, so they've added in that clause. I think that's one of the most finicky parts of the contract, because a lot of times, if contract terminates on bad terms, escrow never gets that actual signed release by both parties, which then that's when they call me and we talk about, the risks of them going ahead and releasing the earnest money, and we hash all of that out. So that's an escrow issue, but it's more clear in the contract now, which is good. Section 21, this is the other big change at the very end on the signature page. There did not used to be a signature to put a copy to be given to the party's agent, to y'all. And I think they've added this because it used to only be, the buyer seller's info was listed. And I think what would happen is realtors would put their info there and some wouldn't forward stuff to their client, and which is bad practice, of course, but those are the actual parties, right? So that should be party info, and then you can put your information now in this new section where it says party's agent. So 3 biggest changes.
Question real quick.
Yeah.
It is always the buyer's agent's responsibility to send all of the fully executed documents to title, correct?
I
Or is
would,
it the
well,
seller? Or is it a one or the other?
one or the other. It depends who's opening title, like who picked the title company is what I would say. Is that,
There's no runnery. I don't think there's a law on that.
there's
Okay.
not, there's.
Or with the best price, or what's like, because I guess I
Danielle?
always thought it was the buyers.
Danielle, we've got a contract right now, and I'm gonna go ahead and send it over to the title company, and even though you're paying for title.
Chances are, I also will request copies of all the executed documents, CC both of us, lender and title company.
It's all about,
Like,
it's
I
all about
always
that communication,
Oh, yeah.
working
I would say
together.
communication and whoever's picks the title company.
I feel like it's whoever executes it. That's kind of been my experience. Is like you execute
buyer,
it and you're
yeah.
gonna send it back to
Oh,
the
yeah.
other party.
Yeah.
If you're
Yeah,
executing
copy.
something, you might as well add title. You might as well add lender. You might as well just do it all right.
My
there.
problem is that I've assumed competency on the other side.
Yeah.
Been hurt by that. Like, I mean, we have stuff that gets executed but never gets sent to the lender, or never, the title company never gets it, and so my rule is just like, I do it.
You
So
always
I know
do
it's
it, like
done,
no
and
matter
if it
what.
didn't
Yeah.
get done.
I think that makes sense, because I think I've always not known, but then I've always done it, and I'm like, well, they're giving it twice.
Yeah.
So I think I always thought it was the buyer that.
Title doesn't care. As long
Yeah,
as they get a
If
copy.
they get the order open, they get things rolling.
They'll take 6 copies if they need it, just make sure that
Yeah.
they get the right.
Okay.
I always shoot the other agent a text like, "Hey, do you have an assistant that also needs this email? Hey, lender, do you need an assistant that also needs title?" And I message everybody
Yeah, like,
because
who else needs? to be
everybody,
reviewed?
every time they send this thing out, they're like, "Oh, hey, can you
Please,
please?"
CC.
Yeah.
And I'm like, "Gosh, I'm sorry, new loop."
Uh-huh.
Trying to
Do
make sure-
you include your clients when you send it to title? In the lender?
That's a great question for y'all.
Not really. I usually send it
Just
differently.
title and lender
Yeah, and the other
and
agent.
other agent.
Because honestly, my brain works on, my clients are different than the title company. The title
Yeah.
company are going to be talking a certain language that they're not going to understand.
Yeah.
We start talking about title commitment, Schedule B, Section 10, Paragraph 10, my client's like,
They're gonna call.
What's that?
going on? What's happening?
what that's,
No, I
what's that
agree.
about?
I would say
So-
know your audience on that one.
That's, yeah,
Yeah, like my realtor knows I want to be on all the emails.
Well,
right?
an attorney.
It depends. Yeah, yeah.
attorneys and
Any
engineers and
attorneys
doctors,
always.
get them everything they ask for 4 days in advance.
And everything they didn't ask for.
Yeah.
Exactly.
You better have that on a spreadsheet.
Other changes from February 1st, we already talked about the required notices. So new terms about additional disclosures, oral leases, financing clauses, we'll go through that. Of course, the copy of the contract to the agents, y'all, we just talked about that on the signature page. And this is straight from TREC. So if you go on that first link, the first slide I had, this is what comes up talking about the changes. So it even says, you see in the red, non-substantive changes based on public comments. And for anyone newer, this happens every fall. So every fall, there's a huge TREC public meeting in October or November. They vote on changes. They talk about things that can make the contracts better and all the forms. They revamp forms every year. And then they go into effect in the spring. So some years they go into effect February, some years March, but every year you can plan on they're going to change something. And some years it won't matter so much, and some years they'll add, whole large sections, which is what happened in 2021. And this is exactly from TREC as well. So it lists all your paragraphs, exactly the changes. They are so non-substantive. I'm not going to go through every single one, but as we go through the contract section by section, I'll point them out. But you can see I've mentioned a lot of them. Paragraph 3 is another change where we talk about the sales price. That is a somewhat major change. It's different. They added a definition of cash portion. And I think that's due to COVID, when folks were trying to make offers look as competitive as possible. They would put a number there that it's cash that's coming from their house sale that's not closed. You know, people were calling cash a lot of different things, or then you'd find out it's actually a hard money lender or owner financing, you know, whatever it is. So now we actually have a definition, and it says does not include proceeds from borrowing of any kind or selling other real property. And then of course, except as disclosed in this contract. So there's still wiggle room, and there's still, you can finagle it, but there's now a definition in the section. I don't think there's any others, you know, super worth noting, but this is exactly from the TREC website. If you ever are curious and want to go look, they've made some minor changes to addendums. The seller financing addendum is one of them. Amendment to the contract, couple things there. Third-party financing. You can see they're all minor words, and they've added lines or check boxes or whatever, but they are all summarized there if you ever want to take a look. A couple more. Your reservation for oil, gas, and other minerals, loan assumption addendum. You know, these are all very specific forms that you have a reason to be using. But we will get into the contract section by section. And I know it's hard to see on here, and I said mostly I'm going to talk anyway. If anyone wants to pull up the new contract, feel free, and you can follow through. But I think it's nice to visually see how not super different the forms are. So you can look at it, and what's one, just a visual difference off the bat from last year.
Wait, which one's the new one?
The new one's on the right.
3A is different. That jumps out to me.
Yep, 3A is different. And even just a color difference.
Yeah.
Yeah, they've taken out your blue boxes. So if you ever on, you know, if you're ever looking at a paper contract or one in color, I say that's a very easy way to tell, you know, which form you're looking at. It's old, but the number one thing you should always look at is the bottom right and the top right. That will tell you what form you're looking at.
Mhm.
So the current is number 20-17, and then we say November 2022 in the top right, because that's when the changes were voted on. This is one thing I think TREC could do better. It would be great if the years coincided and, you know, the TREC number was 2023. But of course, that's the version of the form we're on, is only 17. But that is where you look, and it's very easy to tell. With that, parties, section number 1, very beginning of the contract, you would be amazed how many issues there are with this section when it gets to title. If you do not spell the name right, if you put the wrong person, title's gonna come back with all sorts of questions once it starts, right? And where this really comes up is, let's say you're working with someone in their 30s or 40s, and they're selling their parents' house, but they don't tell you their parents are dead. And so they sign the contract as, I'm the seller, I own this house, I inherited it, blah, 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 blah. But they don't tell you that, no, the deed is going to show mom and dad are vested, right? And so that's what title's for, and that's what they're going to find and come back. But my biggest advice always to realtors, no matter what class I'm teaching, try to have the whole story from your clients when you are working with them and when you sign a contract, and then relay that story to your title team. And that's what I tell, you know, the girls at Fort Worth Title, tell me the whole story when you're asking me an underwriting question, because it'll save a lot of back and forth, and it will save you all time, and you'll close quicker if you give them all the facts first.
Is that just a quick fix in that situation? You just transfer the deed to the
No.
or
That's a great question. So that's another class.
That's a whole other class.
Yeah, so that's I teach a dead people class,
Okay,
which is
cool.
fun. But so no, then the questions are, was there probate? Did they go to
Okay,
court with a
okay,
will?
so that's like not a, like if that comes up, it's like, okay, we gotta.
You have to
Take like
it.
10
It
steps
might not be a quick fix, but typically it's not a
Yeah.
quick fix.
May I interject?
Yeah.
I had one in Saginaw, people from my church. They wanted to sell the house to the neighbor across the street. Mom and dad had just passed away in the last 3 years. So before I ever talked to the people about putting a contract on, I took all of this information to Old Republic, my title company that they wanted to use. And they went through and ran the whole thing, which we had to go and get death records for Mr. Seller, death records for Miss Seller. Then we had to go through, make sure what was probated, what was not, where's the will, where's the heirship affidavit, who are the kids, who's
So
signing what.
obviously do all of that
Before you list it.
Yeah,
Before.
that will save a ton of time.
And it did.
Yeah.
Once we went into the contract, we closed in 18 days.
Yeah.
Once, Savannah, once we went into contract, we closed in 18 days.
Okay, cool.
But it took me 75 to get to
Oh, wow.
listing.
Okay.
Yeah, because there's a lot, they call it curative work. There's a lot of things you have to cure.
Yeah.
So what would happen in that situation is both dead parties would show up on Schedule C of the commitment, that's where escrow works. They have to resolve everything on Schedule C to close.
Okay.
And they'd be calling me, especially when there's no probate or even no will. If you've
Yeah.
ever heard of an affidavit veriship, we'd be looking at doing that. There's just a lot of things you have to decide
Okay.
how we're gonna fix it. But that is the most common example when the party section is wrong. Spelling also sometimes matters, or maybe there was probate and you have one sibling that you're working with, but there's actually 4 and only one of them signs the contract. Not a huge deal,
Is it,
but you're gonna need everybody.
is it best rule of thumb to use the names that were approved by the lender? Like I ran into that issue where it's like on the pre-approval, it was like my client's first, middle name and last name
Oh, I see what you're
on the
saying.
lending documents, but we didn't put that in the contract. So I mean, we just had to do an amendment to change it. But I guess, does it need to be that?
I would say best
That's
practice
sensitive.
is use complete names, and if you have middle names on something, like for some reason, me, with the way my credit has always been, my middle name always shows up. So anytime I buy or sell a house, I'm always Rebecca Marie Adams. It's never just Rebecca Adams.
Yeah.
But some people, my ex-husband, it was only Jordan Adams. So I don't know the rhyme or reason, but it just might get pulled different. So I would keep it however,
Okay.
if you can.
Yeah.
But it's easy if not.
Yeah. It was an easy fix, but I just was like, wow, that seems so
Yes,
specific.
But,
Yeah, like, sure.
but if you had put them in the contract, you wouldn't have had to take I can fix it.
For sure.
exactly. Save time,
Yeah.
quicker close, all that. The other thing, if you have a party, I will say dead people and divorce are the biggest things that cause issues with contracts, closing, all of that. So if you're ever working with someone who says they were recently divorced, are you actually divorced?
Mhm.
Are you separated? There's not a legal separation in Texas. So they're either divorced officially, legally, or they're not. And so just know that. That's something if someone ever tells you, I'm in the middle of a divorce, different things, it's possible to still buy a house, but it's going to open up some other cans of worms. With that, property section number 2, also an area where a very minor error could cause title to come back very wonky, right? So let's take an example of a lot block, pretty simple legal description, right? You put in the lot block, county, the common address. That's what we call addresses in title. We call them common addresses because we don't insure a common address. We insure the actual legal description, meaning the lot block or the long meets and bounds that is 400 feet to the chain link fence, 60 feet to the river. That's what we insure. So you want to be sure it's correct, because if, let's say, you're selling lot 1 of block A, but you put lot 1 of block C, title's going to get run on a totally different property, right? It's going to come back different sellers. It's going to come back totally different things, and then they're going to have to do it again. Is it a huge issue? Not necessarily, but if it took them 4 days to get their exam work, it's going to take another 4 days for them to get their new exam work, right? So just be careful when you're putting in legal descriptions, be sure it's accurate. Improvements, this is where we're describing everything that's attached to the property, right? So when you think improvements, of course, it's a house, of course, it's a building, but it's also those things within a house that are attached to it. And the way you can think of that is, will it cause damage when you remove it? Ceiling fan, things like that, all the things that commonly go with the house when you sell it. And so that's there. And then we have the section about accessories. And this was new in 2021. So with all the new technology, software getting bigger, the contract didn't used to be good about talking about anything, ring doorbells, Nest thermostats, things like that. So now we have a section about accessories talking about controls, software for login, hardware for those things, all of that. And then section D is important. So this is your exclusion section, right? So if there's anything that your seller wants to take with them that would typically be considered an improvement, you want to list there or have an exhibit if there's a longer list. When I bought a house in Dallas, the couple wanted to take a bathroom mirror that was extra nice. I don't know what it was, but they wanted to take that, and they had some other specific things that they just wanted to make sure that were clear that they were taking. So there was a full list attached that showed all the curtain rods, all the different things they wanted to take. So that's where it goes. Of course, section E, if there's any reservation for oil, gas, or other minerals, you're gonna need to use the addendum for that. Pretty straightforward. And then section 3, your sales price, obviously very important. You break out your cash portion, your loan amount, and then that's gonna total your sales price, right? Cash, we talked about it, but there's now a definition of cash. So watch the number that you put there. And then of course, most people, if you're getting a loan with the house you're buying, if it's not a full cash deal, you're gonna have third-party financing addendum, right? If they're getting a typical loan, it's not seller financing or anything crazy.
So Rebecca, just
Yes.
like in real life use
Yeah.
for that, let's
Yeah.
say that we have a seller that's selling their house, they own it cash, they're gonna be buying another house cash, we put 0 there, 0 finance, and then just the sale price.
Correct, correct, because the house isn't sold yet. Yep, exactly.
So you said if they're just, yeah, so if they're buying the house fully in cash,
Yes,
From
Or
the
real.
proceeds of the house that they own.
so it's not cash yet, right? They haven't sold it.
What I
What
would-
would be just closed?
Well, what I said
Yes.
was that if they own a house cash outright and they're selling that in Mississippi and they're buying another house here, they're gonna be paying cash for it from proceeds. That in that first box where it says cash reporting, you put 0 finance, and you put the sale price.
In that situation, I would say you still put the cash amount in the top despite the new definition, because by closing, that's what it's gonna happen.
And it also says not disclosed in this contract. So I would assume you're putting the sale of other property addendum on it, right?
Tax, yeah.
Yeah, so
Yeah,
either
it's
one,
just
as long as one occurs.
and if they are just buying it outright cash, like they just have the money in their bank,
Mhm.
then you would just fill out A and C.
Yes.
Correct.
And it would be 0 on the
Okay.
loan. Yeah, exactly. The whole thing, so any contract, right? There's wiggle room and there's ways to do it slightly differently. I would say the biggest thing, like Danielle said, be sure everything is somewhere that you need, and to follow it as closely as you can with how TREC intends it, to be used. But I will say there are multiple interpretations of this 3-day cash. But now that we have it there, I have an attorney with a different title company that I work with, and he's called me before asking, well, what do you think about this? What do you think about that? Angela, do you have a question?
Yeah, so about what Danielle said, as long as you have a contingency or something like that attached, then you can still add it to cash portion if it's the proceeds of that sale.
Yes. Yes,
Okay.
I agree,
You just have to have the backup
for sure.
addendum to go with that.
Yes,
Yeah.
yeah,
That makes sense.
100%. Any other questions on that section? The press? No? Okay. For leases, this was a brand new section in 2021. It used to not be here at all. And so it should be, common sense that we're disclosing any leases that the property has, right? But this is the section where it tells you you attach the proper addendums. We have residential leases, fixture leases, natural resource leases. So residential, is your typical, you have a tenant in the property, they're gonna finish out their lease or whatever's gonna happen. You check that box, you attach the addendum. Fixture leases, these can be water softeners, solar panels. Those are the most common ones we see. Maybe something to do with a pool. There might be a fixture about that. The reason this matters so much is if you have fixture leases, a lot of times there's also a UCC lien. So there's a lien that goes with it for the solar panels. Maybe they're still paying off their solar panels, they're still paying off a water softener, whatever it might be. And that's going to show up on title that needs to be paid off or assumed and handled. So that is why it's in here. And so of course, disclose to your buyer. Natural resource leases, existing leases affecting the property, you're going to disclose those. And oil and gas leases are going to come up, so long as they're recorded, are going to come up on title as well, with the title company. So that wraps up page 1. Does anyone have questions? So page 2, earnest money and termination auction. Big section, of course, talks about money and it talks about all our timelines. So we've got within 3 days after the effective date, you're putting your escrow agent, your title company, their address, how much money is being given as earnest money and how much is being given as option. So this is a section that, of course, escrow works in a lot. I think it's pretty straightforward for realtors, what's going where. But a new section in 2021 is that number 2, clarifying what happens with weekends and government holidays. It didn't used to be in there. So right when I started underwriting, I got a lot of questions Hey, the contract came in on Friday Friday, Thursday, MLK Day is Monday, they didn't get their money in, it's Tuesday. So now it clarifies, if we have a holiday or it's Saturday or Sunday, it's the next following business day.
The next,
after
it's
that.
due the next day, or does that start day one of the 3 days to get it in?
No, it's only extended until the end of the next day.
Okay.
That is not a holiday or weekend. Yes. But that is helpful now that it's there. I think folks have, now that it's been 2 years, have caught on. I don't get those questions anymore, but I used to get a lot of them. Otherwise, termination option, of course, you're picking your option period, how many days. What standard that most of y'all do? With option period, 7, 5 to 7. Yeah. I think it just depends on your parties and.
That's not what I'm executing.
Yeah, that's true.
When will this be executed?
That's fair.
And if is it a flip, do I need 10 days to make sure that, everything there is good?
Right.
There's a lot, it just varies.
I agree with that. I think I've done 7 a couple times I've thought, but it just depends.
It depends.
It just-
If you've got a beautiful house that's brand new,
Yeah.
that's only been lived in for a year, 3 days.
Probably enough.
If I can call my inspector and say, hey, can you get there tomorrow? 3 days is plenty.
No, for sure.
Actually,
Of course, C and D.
About 3 out of it.
Oh, no,
Sorry.
you're fine. C and D, what happens, failure to timely deliver, just giving your standard boilerplate language, saying that folks may exercise their rights, terminate the contract. E, time is of the essence. I think that's one of the silliest things in the contract, but it's very contract law, language that we're throwing in. And then section 6, this is I would say my favorite section of the contract because it is all title and survey and all of that. But hopefully this is a section where you can learn a little something new about the survey and the survey exception. So first off, section A is about seller providing buyer title policy of insurance at whose expense. So typically always the sellers, right? This is one section where, at one point where I worked for a title underwriter who reimbursed you all these fees during COVID when I bought a house, I was like, oh, I'll pay for title as the buyer, save them a couple thousand, and it made it look a little stronger. But that's where you're putting your title company in again. And then numbers 1 through number 9, that's listed below, it states title policy, will have the following exceptions. So these exceptions are promulgated in the state of Texas, meaning they're mandatory, they're required. So on Schedule B of the final policy, there will always be these exceptions on the policy. It gets difficult when you're dealing with out-of-state parties who have attorneys. They will always ask us to delete the majority of things on Schedule B, but these are what's promulgated. And with that, number 8 is what is commonly called in the industry the survey exception. And so I'm going to read it. The standard exception is discrepancies, conflict, shortages in area or boundary lines, encroachments or protrusions, or overlapping improvements. And it's called the survey exception because this goes on Schedule B. And if it is there in full, what will happen is if your party later on has a survey claim or an issue with one of these things. So let's say a overlap. Let's say their neighbor's fence overlaps onto their property, however many feet. And let's say a year after they buy, the neighbor calls the title company and says, hey, my neighbor's shed is overlapping 2 feet. They won't move it. I have title insurance. I want help. If they send it into the claims department, 9 times out of 10, I can't say 100%, it will always be 9, but because this exception is in full in Schedule B, it is accepting coverage for overlapping improvements. And so you limit your coverage if that whole exception is in the policy, right? So with that, you have options in Texas. We can't totally delete it. Some states you can totally delete it. But in Texas, you can amend the area and boundary survey exception, which is this, to only read shortages in area. And so this is a small cost. It's 5% of the premium. So it ends up being pretty little. But if you check, will be amended to reach shortages in area. You pick who's paying for it. What's going to happen is your policy on that exception is only going to say shortages in area, meaning you've opened yourself up for coverage for the discrepancies, the conflicts, encroachments, overlapping improvements. Because what happens is when a claims attorney gets that claim, They go to Schedule B and they see if the whole exception's there. In some states, I used to do claims for other states. If it was gone, then I would have to cover whatever survey issue came in, right? But in Texas, we make it smaller. So it's only not covered for shortage as an area, but everything else, you're opening yourself up for coverage. So my whole point, this is extra coverage you can buy your buyer by amending it to only storage as an area.
And if say a situation like that happened though, surveyors also have insurance. Right?
Yes, but if they did the survey correctly and it was shown on the survey, they wouldn't have any liability in that situation because the shed is just in the wrong spot, which isn't on the surveyor, right? Because it would be shown on the survey. And you can buy and sell property with all sorts of encroachments, but I'm going to make exceptions for it on the policy potentially. But this is a good spot where you can give yourself extra coverage. Does that make
And
sense?
so then if you give yourself that extra coverage, if the shed is over on your land, then you can make them,
Yes.
that gives you,
You would submit a claim and then coverage would likely be afforded for
Okay.
your claim.
but if you didn't select that, it's like, oh, well, sorry.
Yes.
But that would only be if, when would there ever be a situation that would happen? It would be like if they bought the property and they didn't know that something was overlapping. Oh, so what you're saying is that say the shop that you bought was built 2 feet on the neighbor's land.
Yeah.
Your shop, then those people want you to move it.
Yes,
But
or
that-
vice versa. It could be either way. It
So
could
if
be,
you had the coverage and they wanted you to move it, you wouldn't have to because you have.
well,
the-
so if they sued you, you would submit a title claim.
Okay,
And then that's why you have title insurance, right? For defense when you get sued about title.
Yeah.
But even if they just, send a letter or knock on your door and say, we want you to move it, or if you go want them to move it for some reason, those are all times when you would submit a claim to title insurance.
okay,
Does that make sense?
yeah.
So it's extra additional coverage. Have people heard it called the survey exception before or not? No?
Never
Okay.
really had it explained to me, to be honest.
Okay, no, that's fair. So you're accepting to things that are shown on the survey.
Yeah.
Very in general. And so then you can minimize that exception, which is helpful. Next, the title commitment. How many people have really looked at a title commitment before?
Looked at, yes.
Yeah.
Looked at
And
it.
I don't want to.
Okay, okay, that's fair.
Understood, no.
Okay, so my simple explanation of the commitment is it is the draft of the policy. It's not a policy, but it's a draft. And so you have 3 schedules, Schedule A, Schedule B, and Schedule C. And Schedule A shows your basic info. Think how much the owner's policy is going to be, which is the sales price, how much the lender's policy is going to be, how much the loan is worth, who the insured parties are. So your buyer's names would be listed on the owner's policy. And then there's the legal description, who's the vested owner, all of that's on Schedule A. Schedule B are your exceptions. So it's all these promulgated things that are mandatory. But what comes up on there are all the restrictions for the neighborhood. So if there's a POA, if there's an HOA, things that are recorded affecting the title to your land, they all go there. There's oil leases, oil and gas, they're all going to show up on Schedule B. So those are exceptions. Folks can object to certain exceptions on Schedule B. And it's going to ultimately come to the underwriter if it can be removed or not, dependent on risk. So with that, Schedule C is where all the requirements go. And on Schedule C, that's where all your prior liens go. So your prior mortgage, if your sellers are selling with a deed of trust that they bought their house with, it's going to show on Schedule C. If there's any child support liens against your sellers, they're going to show on Schedule C. Any AJs, abstracts of judgment, meaning you didn't pay your Discover card, they filed an abstract of judgment with the court. Any sort of creditor can have, an abstract of judgment that we call them AJs. All those things are going to show on Schedule C. And the difference between C and B is for escrow to go to closing and for you all to close, C has to be cleared. So they're going to add liens to the settlement statement. You're going to have to pay off all these child support liens to close. Or a lot of times we get really common names, right? John Smith, Juan Perez, all sorts of common names. So it might be a laundry list. If you're dealing with a John Smith, it's going to pull 1 million liens in whatever county you're in.
It might not be your John Smith.
Exactly. And so then what escrow has to do is get info from your client, birthday, social, their last 5 addresses, and they're literally going to do what we're doing here and match up the AJ with your client's info to try to clear them. And so then they might say, okay, we can remove all these. We just need your client to sign an affidavit stating none of these are his. And they're going to determine that they can remove them because the socials are different, the birthdays are different. There's no address they've ever lived at, things like that.
Okay.
But Schedule C, they have to clear. But on Schedule B, if your party has an attorney, they're going to be asking to remove items on Schedule B.
So
potentially.
obviously Schedule C is really important to look at,
Yes.
like to make sure there's not stuff that doesn't belong to your client.
Yes, or if you want to know how many issues there are or how long, title's going to take, if there's a divorce, it's going to come up on there. If there's a probate, if someone died, it's going to come up on there. If there's a missing deed in the history of the property, it should show on there. They'll say there's a gap in the chain of title. Any issue with the title is going to be a requirement on Schedule C. So I would always recommend looking. Some are going to be really clean, right? Ideally, my house in Dallas, if I rent it out, if I go to sell it, it should have my mortgage from when I bought it. And it's going to show my divorce because I got divorced while I owned it and it's my same name. So it'll show a divorce and then they'll say, oh, she's officially divorced, clear, and a mortgage. But other times, there's going to be child support liens, there's going to be AJs, there's going to be anything that's recorded. So also, anyone have clients who file memos of contract? No? Okay. So a memo of contract is, a lot of investors do it. A lot of like fly-by-night people who try to buy a bunch of property. So if you go into a contract with a seller, they will go file this memorandum of contract. And all the affidavit says essentially is, I've contracted to purchase X property, we're under contract. But they file it in the real property records. So it's a cloud, it's an issue because it's filed in the property records. Now, what'll happen is they won't buy the property. And then your client will go to buy the property a year later, 2 years later, 6 months later. And title's going to find, oh, well, there's this memo of contract Rebecca filled out and recorded 6 months ago. Who is she? Why didn't she buy the property? And it's considered a risk to title insurance because we have this affidavit saying a totally different party wanted to buy the property and supposedly was under contract. But those show up on Schedule C too.
So why would those people do that? Pay out?
It's a great question. Yeah. Sometimes just to secure that they want to know, that we're under contract and they know that it will become a cloud on the property. Some people, if they're litigious, that's just their practice. They will always file one. I don't really know, but
I guess so it doesn't get sold out from under them.
That's the goal. I mean, they think if they file something, it's going to get located and then it shouldn't be able to close, which it can't. If it's recent enough, we want those released. So we'll require. What was that? A memo of contract?
Okay.
Yeah, memorandum of contract. Yep, memo of contract.
Do you know is there a way to for these C requirements to look that stuff up prior to getting to being under contract and title tools at all? You know what I mean? For your clients.
Well, so most counties are online.
Yeah.
So Tarrant, so you would pretty much be an examiner and go in and search your party's name.
Okay.
So you would look for the Tarrant County real property records.
Okay.
And you could type in the property address, their name, and it would pull, ideally it would pull deed of trust, if those are the only things. But then yes, it would pull other things. It takes some time. I don't know how good Tarrant County's website is, for a common person who's not an examiner, but you could definitely try it.
Do y'all would y'all have this type of conversation with your clients before? Hey, do you have any unpaid stuff, any child support, or you know what I mean? Or do you just wait till you get to this point and
I usually
let it
ask.
maybe pop up?
I usually ask.
Yeah.
And the lender might also already know some things potentially, but tax liens, the lender might know.
I don't know. I've never asked, never had a conversation ahead of time. I just assume that if it's gonna come up, it's gonna come up in the title work. I mean, either way, if you have to move, you're gonna have to deal with it.
Yeah.
Now I will say,
It's come up in there before.
what did you say?
I've had federal taxes show up.
Oh yeah,
before, and
federal
I'm
tax liens are not fun.
Here they are.
Yeah.
Yeah. I had a client who's we got to title and there was a lien on them.
Yeah.
And so I was just curious looking back, gosh, should we have looked into that before? Or you know what I mean?
Yeah.
Is it,
I mean, I would
they didn't even know they had the lien on them.
Well, and a lot of people don't. I mean,
Yeah.
child support liens, they can be 30 years old and they've
I
forgotten about it.
mean, you can open title before you go under contract. So
Yeah.
like when you put it on the market, you can send it to title and just, if you have a title company that you work with.
You could.
And that's like if you've ever seen in the MLS, it says, please do not change title company,
I was already.
title already open.
Okay.
Yeah.
That's what that
Or if you
is.
have, say you have a party that, I don't know, you feel weird about, or you, for some reason,
Yeah,
think
maybe
there's
it's like-
gonna be stuff,
Yeah.
you could do that early.
Okay.
I will say the vice versa sometimes happens where, maybe, let's say they're like a 1099 employee or something, and so they pay taxes every year, and they haven't paid, and they know that they owe the IRS. So you'll have the situation of nothing being reported, but they're a very nice person and they'll tell you, that we owe X amount. And that gets a little different because, if there's no actual lien reported, I don't care on title. Because what the theory is, if a lien gets recorded while they own it, it's post policy, right? It came after the policy. I didn't know about it. It wasn't recorded, lower risk.
Okay.
But I mean, people might tell you different things. It
Yeah.
just depends.
Okay, cool.
Yeah, that's a good question.
I mean, but the solution for that is it just gets paid out at closing, right?
Yeah.
Yeah. So I mean, it's not like it's necessarily a deal breaker. It's just
For my
your bottom
clients,
dollar
they
is.
couldn't pay it out because it
None
was
of the
too,
proceeds.
yeah, and then they needed the proceeds for the buy, and so it's kind of like.
Yeah. And that's where they really become issues, where there's a ton of them or there's
Yeah.
not enough money. Yeah,
Mhm.
exactly. But the commitment, I would encourage everyone, get familiar with it. It's useful,
Yeah.
100%.
That was very helpful that you went over that, because I never.
Okay, good. Good. The survey, top of page 3. Of course, this is where you're saying, the seller shall furnish a survey. T47 affidavits, is everyone fairly familiar with them? Okay. So the theory with the T47 is if we have an old survey, we'll have the seller sign a T47 to account for any changes since the date of survey. Now sometimes if it's a really old survey and, 3 people have owned it since, that's when your seller, might say, oh, well, the last title company also had a T47. And then you'll track the, title, track those down, and there'll be multiple to account for all the years. People always ask, what's too old of a survey to an underwriter? Some bigger underwriters are really strict or more strict about how old a survey can be. I'm cool with very old surveys so long as we have the T47s and if it's legible and I can read what's on it. Because there are some, 70s and 80s where they weren't quite hand-drawn, but they were almost hand-drawn, and you're not reading the meets and bounds. You can't see the house. Maybe there's no setback lines on it then, whatever the case might be.
As an underwriter, do you ever pull up Google Maps and look at the survey in the Google Maps? Is that like you?
Yes,
Okay.
always. Or if a T47 says, a pool was added and a patio, and you see it's a real small lot, and I'm like, I don't see how it doesn't go into the easement, or I don't see how it doesn't hit the fence, or yes. Oh yeah, we look at that stuff all the time. For sure.
I do have a question. I've gotten conflicting
Uh-huh.
data on this. Who can sign T47? I've been told that as realtor, you can sign the T47 for your client. Because it says property owner or someone with relationship with the property or property manager or someone of that profession.
I would never, if I was a realtor signing T47, I would say no. I would say the property owner. Now when I got divorced and then I sold my house, and they were cool with either one of us signing. The title company didn't require both of us sign one, but I would say I wouldn't as a realtor. Because
I feel like there's not like a best practice for T47s because it has to be notarized. It has to be like, it's not convenient.
No.
And it has to be turned in, I forget what the contract says, within a certain amount of days.
Yeah.
I've had title companies where they let us do it at closing.
Yeah.
Like if they know that everything is fine, but the problem is like, if it's not fine,
Right.
I need a new survey, but like, a lot of people don't have access to a notary. Like a lot of people don't have the time to just go and, is there a best practice for that?
Get your notary.
You become a notary, is that what you said?
That's what I am.
Yeah.
I'm a notary.
I would say a lot of people go to the title company and get it notarized. I went to UPS because the house I was selling was in Spring, Texas,
Right.
north of Houston.
Right.
So
You're not driving
I went
yet.
to
Yeah.
UPS. Yeah, you could do, but I mean, a lot of clients don't want to go make a trip right to UPS or whatever. But I would say maybe encourage the title company if people are local.
Okay.
Swing by there, they'll notarize it for you. Other things with the survey, those are of course just the dates you have to have in, objections, you can always object to items on Schedule B. And then Section E, I always say is like the lawyer language section, because you can see there's no boxes to check. for the most part, right? It's just all language.
Do not change this.
Yes, yeah. The only one, number 2, property owners association, you're checking if it is or is not in mandatory membership. And then you get to number 11 under that section, and that's where we've added the line where you can list mud or pit. So now there's a spot in the contract for that. Property condition, of course, we have to have seller's disclosures. You're going to state that they already have been given them, if it was within MLS and everything, or when they're going to be provided them. Number 3, I've only had come up once or twice. The seller's not required to furnish the notice. Under Texas law, that's pretty specific. Sometimes it's a family deal where they wouldn't be required to disclose. I would say best practice, always do disclosures no matter what the relationship is.
Even if it's NA, even if I don't know.
I totally agree. So I would always do that. Lead-based paint, always, acceptance of property condition. That goes into the next page. Accepts the property as is or as is with specific repairs and treatments. So this is, of course we all do inspections, and then we have our laundry list of I want you to do X. If there's something major that you already know about, or I don't know, a great example, it could go ahead and be here, but you cannot put general info here. And that's what TREC says. Do not insert general phrases such as subject to inspections that do not identify specific things. So just keep it specific. E through H, again, we're boilerplate. Number 8, I get questions about this sometimes. This is disclosing if you're related to the party you're representing. But someone pointed out once it does not list sibling in the specifics. It says spouse, parent, child, business entity, trust. I would say if you're related in any way, I would disclose it.
So we're on number 8, right?
Yes.
Okay, so I had this come up with a deal that's closing next week.
Mhm.
Normally, if I am an agent, I'm selling the house, I have to disclose if I'm an agent.
Yeah.
Say I'm selling Gracie's house. Does that still need to be disclosed if Gracie is the realtor? Or she is a licensed realtor, but she's not the realtor representing the deal? Because I was told, yes, it always has to be disclosed.
That if the owner is with
But they're not privy to the party other than, they're not privy to the contract other than in the selling capacity. They're not.
right.
That's where I was like, I was told it always has to go in, but in my mind, that's not what it's asking for.
So I've never been asked this. So it says
Okay.
requires a real estate broker or sales agent who is a party to a transaction or acting on behalf of. So I would
So
say
then,
if they
yes.
are a party to the transaction,
Okay, then yes.
no
Even if
matter
they're
in
not
what
on it.
capacity.
Okay, then
Exactly.
there you go.
I would agree with that.
Okay.
Closing, of course, you're putting in your closing date. There's all the requirements for closing. I think it's important, especially with like younger buyers or first time homeowners, to understand about closing, that it can change for reasons. You can agree that it can be earlier. You can, if folks in the transaction are in agreement, it can be later, right? It could happen on the exact day, but stress the importance of, if you're a buyer, your lending needs to be done by the closing date and all of that. And of course that goes into the dates that you're picking.
That's what I learned yesterday.
Yes.
This is a general suggestion. This does not have a time of the essence clause
Yep.
attached to it.
Yep.
So the closing date is a general suggestion of when we want to close.
Yes.
However, in my case, I'm fighting emails right now. My seller doesn't want to sign because the buyer's not ready to sign, not ready to close today, and they want to close next Tuesday. So he wants them to add $5,000 to the deal, which means they would have to go back through underwriting. And so we're not going to close.
Yeah.
And these buyers are low-income buyers, and they're not going to be able to close on their dream house with 8 kids.
But
It's frustrating.
for the contract, they have 7 days, right?
That's not what that says.
Within 7 days after objections.
After the objection
Right,
made in
that's the
paragraph 6D.
If you
So
put it
it's a
in-
general suggestion of May 31st. If they don't have us an extension to us and he doesn't sign the extension, then they're out of
Oh,
contract.
yeah.
They're out of
yeah.
contract. And the other thing that I learned from an attorney, sorry, I know we're
No,
going
you're
long.
fine. No, you're good. I chat a
Default,
lot. So.
default is not automatic. So if somebody doesn't close, they're not in default until a court decides that they're in default.
Yeah, or until the other party says, you
You're-
defaulted, I'm terminating.
Yeah, and you
You have to
default.
take some action.
There has to be some
Yeah,
action.
you're totally right.
And you only have to do an addendum if you're like to change the closing date if you're closing after the date that's suggested. If you're closing anytime before,
That can be agreed on.
It could be agreed on. Yeah, I would
okay,
say.
but if you're closing before, you don't need any
I mean, the
extra.
contract already says on or before.
Yeah.
So I say no addendum for before
Okay,
unless the
but
party
if
really
after,
wants.
then
Yeah.
you want to get that.
What were you gonna say?
Never mind then.
You sure? Okay.
I haven't closed after a closing date without an amendment signed.
Well, and I think
Yeah,
that's okay.
sure.
So I honestly,
Everybody on the same
everyone's
page.
cooperative. I mean, cooperation and communication, if you have everyone on board with that, it's not gonna make or break anything.
Now, the kind of similar in the
Uh-huh.
situation is like, I'm thinking the reasons why you close late is mostly because of the contingency. Crazy situation I have had
Mhm.
is a 1031 exchange
Okay.
where they
Oh.
close, and closing and funding can be weeks apart,
With
which means that
31.
possession's weeks apart from when you actually close on them.
Yeah.
That's bizarre.
That is crazy.
I have buyers that were victims of wire fraud at the closing table.
Ooh.
And reading this, like the sellers didn't even give us the opportunity to renegotiate, like we didn't have any opportunity to like get their earnest money back or to try to figure out a way.
They just said no.
They just said no, took the earnest money and put it back on the market. And it's like, now is that really what should have happened?
Right.
Is that what the contract actually says? I don't know.
Well, and the contract, I mean, every contract, even this one that's promulgated from TREC, right? You're gonna have attorneys argue all sorts of different ways
Right.
when things happen. Which makes it, frustrating. And that's where escrow gets caught in the middle of things because they want, party wants earnest money or whatever, but they have liability as the escrow team and could get sued. And so that's why they often ask us, which is hard for me because, it's not an underwriting question, that's an escrow matter. So it goes back and forth. But the last couple of things, possession, of course, you're checking, upon closing and funding, or if there's a lease, you're gonna check that box. Special provisions. I've heard a lot of realtors don't use the special provisions section. A lot of brokerages advise, not to. So that's something I always hear mixed things on. Settlement and other expenses. If seller is going to pay an amount of closing costs, you're going to put in your insert amount there. And then we really have a lot more legal jargon because there's no other sections for y'all to fill out. A lot of this is standard for all contracts, mediation section, attorney's fees, representations, federal tax. And then the escrow section, that is where escrow is living when things go wrong. So that's where they added, a release needs to be signed before releasing any earnest money. And that's where they really get tied up as escrow officers because, when it's, a conflict termination, people are upset, people don't want to sign anything, and it's hard to get that. And then you get to your signature page, and this is where we have the new section under to buyer and under to seller, the very last line with a copy to buyer's agent and with a copy to seller's agent.
Mhm.
So that's where y'all's info goes, and then your parties go up top. You don't feel like you learned or heard something?
Oh, yeah.
Oh my God.
Okay, good. Okay, good. 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 I could talk forever, so we stayed pretty good at 1 Sunday.
Yeah.
And y'all had great questions. Sometimes I do this class and it can be very boring because, it is a contract class,
I'll
but
always have
sometimes
questions.
everyone just looks at me and I'm like, this is not fun for anyone.